Today on Capitol Conservatives, Senator John Kennedy doesn't hold back as he grills yet another Biden nominee, exposing incompetence, dodged answers, and even past accusations of dishonesty. This is one hearing you need to see to believe. Before we dive in, make sure you hit that subscribe button so you never miss a moment from the halls of Congress. From the start, Senator Kennedy wastes no time. I asked this nominee to explain the holding in Obergefell. They stumble. I haven't had the occasion to deal with that issue. I don't recall that specific case as I sit here in front of you. Think about that. A high-level nominee who can't recall one of the most pivotal Supreme Court cases in recent history. That's not just concerning, that's unacceptable.
Tell me what the holding was in Obergefell.
I haven't had the occasion to deal with that issue. I don't recall that specific case as I sit here in front of you.
Then I bring up a brief they signed years ago, claiming assault weapons may be banned because they're extraordinarily dangerous and not appropriate for legitimate self-defense purposes. When I ask them to define what they meant by assault weapons, they admit, I'm not a gun expert, yet they advised a court to ban them. They say they didn't write the brief, just signed it. But a signature means you're telling the court you stand by every word. So I press harder. Tell me what you wanted to ban. Still no clear answer.
When you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. You wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by...
You signed the brief, though, didn't you?
Correct. I signed the brief.
When you sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay.
So
they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy. Okay. I would never sign...
Tell me what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10 years...
You were giving the court advice about, say, ban assault weapons. You told the court you were an expert. Just tell me what you wanted to ban.
I was not responsible for researching the content.
You were responsible for the brief.
Absolutely. And sitting here today, I do not remember the characteristics of that were cited in the ordinance for the assault weapons ban.
Next comes the part that makes the room go silent. I ask, you have a history of lying to your professional colleagues, don't you? They deny it. But then, I read an email from a former public defender, Stephen Shankman, a private message warning colleagues about this nominee's unfortunate pattern of behavior and urging others to proceed with extreme caution. That's not my opinion. That's from someone who worked alongside them. I move to another question. Tell me about the privileges or immunities clause. The response? Halting, uncertain, filled with UHS, and I believe it's part of the First Amendment. For anyone who's read the Constitution, that's a glaring error. And when I ask if Congress can legislate in any area not prohibited by the Constitution, they answer incorrectly again.
You have a history of lying to your professional colleagues, don't you?
That's not true, Senator.
Okay. Do you know a former public defender named Stephen Shankman?
I knew who he was, yes.
Well, in a private email, not meant for public consumption, to another one of your professional colleagues, this is what Mr. Shankman said, talking about your lying. He said, it is unfortunate that this is not the first, second, third, or whatever occasion that this sort of thing has occurred. But everyone should be aware of this unfortunate pattern of behavior. You should be aware, he said to the other lawyer, before the other lawyer dealt with you. Your client should be aware, and you should proceed with extreme caution. Mr. Williams, tell me about the privileges or immunities clause.
Thank you for the question, Senator. The privileges and immunities clause.
Privileges are immunities clause.
Right. That's part of the Bill of Rights and part of the, I believe, the First Amendment. It's been a while, Senator.
Can the United States Congress do anything, legislate in any area that the Constitution doesn't prohibit?
Thank you for your question, Senator.
You're welcome.
That would be correct. I believe it's under the 10th Amendment.
I don't think that's right, Counsel. You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending. that you've declined to decide. That's more than any other district judge in the entire Seventh Circuit. In fact, you rank 7th highest nationally.
You are the first to tell me this.
If you believe nominees to the federal bench should know the basics of the document they'll swear to uphold, click subscribe right now, because we'll keep holding them accountable. Finally, I bring up their track record as a judge. You have 125 motions pending that you've declined to decide, more than any other district judge in the entire 7th Circuit. In fact, you rank 7th highest nationally. The nominee seems unaware of this fact, but the numbers don't lie. This wasn't just a bad day for one nominee. It was a window into a pattern of unprepared, unqualified, and in some cases, dishonest individuals being pushed forward for lifetime appointments. At Capital Conservatives, we believe the American people deserve better, so if you want more unfiltered coverage of moments like this, subscribe and join the fight to keep Washington honest.